Good morning, everyone, and thank you for joining us. My name is Connie Chung, and I'm here today with my colleagues Brian Waslu and Jackson Lund. We have approximately 3,200 people registered for today's webinar, which reinforces the importance of today's topic, terminating employment, key considerations, and best practices. The format for this morning will be as follows. We will present from 9 a.m. to roughly 10 a.m. and then answer questions until 10:30 a.m. If you have a question for us, please type it into the Q&A box on your screen, not in the chat box, which should be disabled. We'll do our best to answer as many questions as we can, and if we don't get to your question, please reach out to us after the presentation. Finally, a recording of this presentation and the slide deck will be on the homepage of our website in a day or so. So let's get started. We're going to be covering an important topic today that arguably impacts all employers, regardless of the industry, location, or types of individuals they employ. Termination of employment can occur in a variety of circumstances, from organizational restructuring and economic downsizing to individual cases due to performance and misconduct. We'll spend some time today talking about key considerations and best practices for employers to keep in mind to mitigate the risks that are often associated with terminations. I'm going to kick off our discussion today by talking about the importance of employment agreements, specifically how termination language can impact an employee's termination entitlements. We'll review some recent case law where the specific wording of termination clauses was challenged by the employee and look at what the court ultimately decided in terms of the enforceability of the language. I'm also going to talk about fixed-term agreements, including the risks of having these types of agreements and what our recommended best practice is if you're contemplating entering into this type of arrangement. Then I'll hand it over to my colleague Jackson, who will cover the concept of constructive dismissal, including the types of changes in employment terms and conditions that increase the risk of a constructive dismissal claim and how to reduce those risks, as well as how condonation and mitigation may impact an employer's liability in a constructive dismissal claim. And finally, I'll hand it over to Brian, who will take you through the do's and don'ts as it relates to termination, what needs to be included in the termination letter, how you should conduct a termination meeting, as well as post-termination conduct that may attract additional damages. So let's start with employment agreement language. In an employment agreement, specifically a termination clause can be an important tool to limit an employee's entitlements upon termination. In addition, it also provides certainty and clarity to both parties. Generally speaking, there are two sources of termination entitlements. The first is what we refer to as common law, or reasonable notice or pay in lieu. In addition to pay, common law notice takes into account the loss of benefits over the course of the notice period. Common law is based on prior court decisions or case law. There's no set formula for calculating an individual's common law entitlements, as it is based on various factors such as their age, position, length of service, and the nature of employment. The second source of termination entitlement is employment standards legislation. Legislation such as the Ontario Employment Standards Act will stipulate an employee's minimum statutory entitlements upon termination, including their termination pay, severance pay if that's applicable, and benefit continuation. Unlike the common law, there is a clear formula for calculating entitlements under the employment standards legislation based on an employee's length of service. Generally, common law entitlements are also much higher than what is required under the employment standards legislation. And out of these two sources of termination entitlements, the assumption is that employees are by default entitled to the greater of the two, which is common law reasonable notice, unless there is an enforceable termination clause that limits an individual's entitlements to something less than common law reasonable notice, such as the employment standards minimums. So you might be wondering, when is a termination clause enforceable? A court will not enforce a termination clause unless it clearly limits an employee's entitlements to something less than the common law reasonable notice. And whatever that clause does limit the entitlements to It has to be greater than or equal to employment standards minimums in all circumstances. This includes potential circumstances that may not even apply to the employee whose employment you're terminating, such as additional notice entitlements required for a mass termination or termination for willful misconduct. What we've seen in the case law is that even if one part of the termination clause is found to be unenforceable, a court will likely find the whole clause unenforceable. And the result of a clause being unenforceable is that the employee will be entitled to their common law reasonable notice. It's also important to note that employers have tried to rely on the saving provision in employment agreements, which effectively tries to save the remainder portion of a provision where the court has found one part of the provision to be unenforceable. And you'll see in the next couple of cases that we discuss why, unfortunately, this hasn't worked. So a termination clause will be found to be unenforceable if a court finds that it provides less than the statutory minimum and therefore is considered to be contracting out of the legislation. This form of contracting out is expressly prohibited by the legislation. Courts have found common forms of contracting out to include not providing statutory notice for just cause termination. It is important to point out that there are generally two standards of cause. Even if an employer can prove just cause at common law, they may still owe the employment standards minimums unless they meet the stricter willful misconduct standard as described in the Ontario Employment Standards Act. Another example is not addressing the potential for statutory severance pay. Although there are certain criteria that must be met in order for an employee to qualify for statutory severance pay, not including the potential for an employee to be entitled to this can be problematic. Keep in mind what we talked about earlier about the importance of the termination clause, maintaining compliance with ESA standards, even for potential circumstances that may not apply to the particular termination you're doing. So even if the employee whose employment you're terminating does not qualify for statutory severance pay, not including this in your termination clause can be problematic. The third example we've listed here is that the ESA requires benefit continuation for a statutory notice period, and the failure to reference this can be viewed as improperly trying to contract out or omit a legal requirement. And the fourth point is the calculation of termination pay. So statutory termination pay must be paid on wages, which is broadly defined to include overtime pay, holiday pay, and vacation pay, just to name a few. And if your termination clause limits statutory termination pay to be paid only on base salary, that is effectively less than the statutory minimums. And on this last point of withholding termination pay, there are very limited circumstances where an employee is permitted to deduct or withhold termination pay. And therefore, any clause that references withholding termination pay can and may be viewed as repudiating the employment agreement. So in the next couple of slides, we're going to go through a few cases where the court found the way that the termination provision was drafted could be interpreted as a form of contracting out of employment standards. We're going to start with Waxdale, and in the employment law world, the Waxdale case is very well known and widely cited by plaintiff lawyers when trying to challenge the enforceability of a termination provision. In Waxdale, the employee was dismissed without cause and challenged the enforceability of the termination clause. Although both parties in this case agreed that only the for cause clause was unenforceable and the without cause clause was actually enforceable, the court struck down the entire termination clause and decided that Waxdale was owed common law notice. The court ruled that it didn't matter that the for cause and without cause clauses were separate. Further, the employer could not save the contract with its saving provision simply because the part of the clause that it was trying to rely on was enforceable. Effectively, one bad seed spoiled the bunch. In its decision, the court held its interpretation encourages employers to comply with the minimum requirements of the Act and also recognizes the power imbalance between employees and employers. And we'll see how courts are trying to come to a fair conclusion that holds employers to what one would view or argue to be a very high standard of being clear and precise in drafting clauses when trying to limit an employee's entitlements to their statutory minimums, in light of the traditional assumption of this significant power imbalance between the employee and the employer. The Waxdale case really compelled a number of employers to carefully review their for-cause language in their agreement to ensure that it complied with minimum employment standards, even though the clause itself may not be triggered in a termination without cause. And following the steps of Waxdale, Dufault is another recent Ontario case where an employment agreement was also heavily scrutinized by the court. In Dufault, the employee signed a 2-year fixed-term employment agreement and was terminated without cause after working for approximately 2 months. The employee argued the termination clause was unenforceable for the following reasons. The employee would not receive statutory termination or severance pay if terminated for cause. The termination pay was based on base salary, not wages. And the employer had sole discretion to terminate employment at any time. The Superior Court found the for-cause termination provision was unenforceable in this case, as it was seen as contracting out of the minimum legal requirements of the ESA. Now, although the Ontario Employment Standards Act does not define what cause is, an employee only loses entitlement to termination pay if the termination is due to willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. The ESA standard sets a very high threshold for cause that is much stricter than the just cause standard in common law. The termination clause in Dufault stated the employer could withhold ESA termination and severance pay when the employee is dismissed for cause. And the court also took issue with the open-ended language stating that cause shall include but is not limited to the ESA standard. The court interpreted this to set a lower standard where theoretically, the employer could terminate employment without notice for reasons beyond those permitted by the ESA. And therefore, the clause was held to be contracting out of the ESA. The without cause portion of the termination clause was also found to be unenforceable in Dufault for the following reasons. The termination pay was based on an employee's base salary rather than regular wages, which is required by the ESA. The court also took issue with the language that the employer had sole discretion to terminate the employee's employment at any time. And the court found this wording problematic as the right to dismiss an employee is not absolute. There are certain circumstances prescribed in the ESA where an employer is prohibited from terminating employment, such as at the conclusion of a job-protected leave, or as an act of reprisal for an employee attempting to assert their right under the ESA. And ultimately, Dufault was entitled to damages based on the remainder of the fixed term contract, which we'll also talk about a little bit later. The employer in Dufault appealed to the Ontario Court of Appeal, and the Ontario Court of Appeal affirmed the decision of the lower court. The Court of Appeal agreed that the for-cause termination clause was broader than the narrow ESA exception for willful misconduct. The termination provision also failed to comply with ESA minimum standards. And in following the Waxdale analysis, the unenforceability of the for-cause clause itself was sufficient to render the entire termination provision unenforceable and therefore dispose of the appeal. Now, it's important to note that the court did not offer any comments or guidance on the lower court's decision of the inclusion of the use of the phrase sole discretion or at any time in the without cause section of the termination provision. And while there remains some uncertainty here as to whether or not that language will hold, until the lower court's decision is overturned, this is the law of the land, and it's important to review the necessity and implications of including this type of language using employer's sole discretion in your agreements and whether or not that opens up the risk of the clause being challenged by plaintiff side lawyers. In this next decision out of Alberta, Singh and Clark Builders, the employee was a seasoned executive hired as the VP of corporate operations and worked for approximately 6 years. The employee in this case argued the termination clause was unenforceable as it was ambiguous. The clause at issue specified a 90-day notice period if terminated by either the employee or the employer. And the employee argued the clause only said his minimum entitlements rather than his maximum entitlements. Now, the court did not find in favor of the employee in this case and found that the clause really could only have one meaning, which is the employer can end employment by providing 90 days notice. It is important to point out some of the contextual factors of this case. The employee was a sophisticated executive with experience negotiating employment agreements. And prior to accepting his offer, the employee had actively negotiated and modified his employment agreement, including the termination clause language. So although sometimes it seems like court decisions are everywhere and inconsistent, judges are trying to do the equitable thing. And this case is a good example of where the equities did not fall on the employee's side. The employee in this case drafted the very clause that he tried to then challenge, and the court is not going to look favorably on that. Another important thing to note out of this case is whether a lawyer is involved in the negotiation of your employment agreement. Sometimes employers are often reluctant to have an employee's lawyer participate or be involved in negotiations, but oftentimes that might not be a bad thing. As you see in this case, if there's ever a dispute about the equities of the case, if we can show that the employer received legal advice, independent legal advice, or played an active role in negotiating their termination clause, then that traditional assumption of a power imbalance between the employee and the employer no longer holds. One of the arguments that was also brought up in this case by the employee was that his eventual promotion to COO and subsequent role changes rendered the original contract obsolete under what's known as the changed substratum doctrine. The changed substratum doctrine contemplates a significant change in the employee's role that results in the original employment contract no longer reflecting the current relationship. The court rejected this argument on the basis that the employee's promotion to COO was contemplated and agreed upon at the time of hiring, and therefore the contract remained applicable despite these changes to his role. Now, although in the previous case, Singh was not successful in arguing the changed substratum doctrine argument, the case here in Celestini and Shop Logics is a good example of where the court did hold that the doctrine did apply. So Celestini, after he founded the company in 2002, sold the company and became the chief technology officer. His agreement contained a termination clause limiting his entitlements to 12 months' notice or pay in lieu upon termination without cause. Over time, the employee's role substantially evolved beyond the original CTO position. The parties entered into a new bonus plan, which significantly increased Celestini's compensation, as well as giving him greater managerial and operational responsibilities. He went from having no direct reports to directing managers and staff. Now, in 2017, Celestini was dismissed without cause when a third party acquired ShopLogic's shares, and the company paid him 12 months' notice and a prorated bonus. So Celestini sued for wrongful dismissal and argued that the termination clause was no longer enforceable and that he should be entitled to his common law reasonable notice on the basis of the changed substratum doctrine. Now, the court in this case found in favor of the employee and agreed that the historical termination clause no longer applied. Although there were no changes in his formal job title, there were significant and fundamental changes to the employee's role, which, unlike in the previous case we talked about, were not contemplated at the time that the contract was entered into. Further, the contract did not expressly state that it would continue to apply. The court awarded close to $500,000 in damages. And also, the court affirmed that the employment contract can potentially oust the application of the changed substratum doctrine, but only if the termination clause clearly and expressly does so. On the topic of having clear language in a termination clause, Briggs, this next case, is another example of why it is important to have clear and unambiguous language. So, Briggs was a customer service manager at ABC Insurance, and he was terminated for cause after refusing to comply with the company's return to office mandate after he'd been working remotely during the COVID-19 pandemic. His termination clause stated the employee and the employer agree that reasonable and sufficient notice of termination by the employer is the greater of 2 weeks or any minimum notice required by law. On the issue of enforceability of the termination provision, the employee argued the clause was unenforceable due to ambiguity, since it did not reference the relevant statute when it said required by law. The BC court agreed with the employee and found that the phrase any minimum notice required by law could refer to both either the common law notice or the statute. And this case is an important reminder that any clause where we're attempting to reference minimum legal entitlements should clearly include and state the employment standards legislation. The last case we're going to talk about is one of my personal favorites for two reasons. One, because it's one of the few cases where the termination clause was held to be enforceable. And two, because the team at Shared Coos here drafted the termination clause. So in Birch, both the motion judge and the Court of Appeal in Ontario upheld the enforceability of a termination clause. And the clause itself, which we've paraphrased here, said the following. If you were terminated with or without cause, you would be provided with the ESA minimums. However, there are circumstances where there is no entitlement to notice or termination and severance pay, as contemplated by the ESA's willful misconduct standard. The clause also explicitly stated that its compliance with ESA minimum requirements would satisfy any common law or contractual entitlements to notice of termination or pay in lieu. And the last point was that the clause would apply regardless of the duration of the employment or any changes to the position or compensation. This case really provides employers with a positive reminder that, although difficult, it is possible to limit entitlements upon termination to ESA minimums if certain criteria is met. And although the employee did try to argue that the clause was unenforceable, the court disagreed. The termination clause in this case was clear and unambiguous. And unlike the language in other cases we've discussed, the clause in this case did not allow the employer to terminate employment at any time. Further, the exclusion of common law reasonable notice was clear. And finally, there was really no reasonable interpretation of the clause that could be viewed to be contrary to the ESA. Now, as you'll see in the few cases that we've covered today, courts will scrutinize language very closely to determine enforceability, and it is extremely difficult to draft a termination clause that both limits an employee's entitlements to employment standards minimums and will be ultimately upheld by a court. Practically speaking, there really is no other area of employment law with such a low rate of success for employers. And we definitely share the frustration that our clients feel, where it almost feels like employers can really never get it right. But that's also why we encourage you to regularly review your employment agreements to ensure we can keep up with this rapidly evolving legal landscape, particularly in Ontario. And if after reviewing the cases that we've covered today, you do find that there are gaps in your employment agreement, it's not too late to update them if it's done properly. Our recommendation would be to consult with a knowledgeable employment lawyer like us so you can update your agreements for both new and existing employees. Last tidbit I'm going to go over is fixed term contracts. So oftentimes we'll have clients see the potential pitfalls of a poorly drafted termination clause and wonder whether a fixed term contract could be the solution to all this. A fixed term agreement generally has a set start and end date. And while the concept of a fixed term agreement may seem like a good idea to provide certainty to both parties as to what happens when the relationship ends, if the agreement is ended early, the employee is entitled to be paid out the remainder of the term unless there is an enforceable early termination clause. And if you think back to the case in Dufaux that we talked about, the court awarded 101 weeks of notice to Dufaux after the termination 2 months into a 2-year fixed term agreement. So in that way, fixed term agreements may not necessarily limit termination risks as much as we think it will. In this case that we're going to talk about from the Ontario Court of Appeal, the employee was hired on a 1-year fixed term contract. The agreement included both a for-cause and without-cause termination provision. And 6 months into the term, the employee was dismissed without cause. He was paid 4 weeks' salary as per the termination clause. In this case, the parties agreed the termination clause was void because it contravened the ESA. And generally speaking, the liability for an invalid termination clause would be the full term of the contract, and in this case, the remaining 6 months of the term. Now, the employer here took a run at a novel argument. Specifically, the employer argued that the fixed term clause was, in effect, a termination clause. And therefore, if one termination clause was void, then using the Waxdale train of thought, all termination clauses are void, including the fixed term clause. The employer made the argument that the damages should be based on common law reasonable notice, which in this case would be less than the remainder of the contract based on the short service of the employee. The court did not like this argument and rejected it and found that the invalidity of termination clauses did not void the fixed term clause. The Ontario Court of Appeal found the employee will be entitled to receive the compensation they would have earned up to the end of the fixed term without a duty to mitigate, which we'll have Jackson talk about a little bit later in the presentation. Now, a lot of people have viewed this decision really as another creative way that the court has found to increase the damages payable to the employee upon termination, but also a good reminder of the potential pitfalls of having a fixed term agreement. So, like I mentioned earlier, although a fixed term agreement may seem like a good idea, there are a number of risks which can increase an employer's liability. And one of the biggest risks in having a fixed term agreement is if the employee works past the end of a fixed term agreement, even if it's only by 1 day, this may effectively convert this agreement to an indefinite term agreement. And our best practice is to ensure that employment ends or a new agreement is signed before the end date. This will likely require some very diligent administrative work in keeping track of the dates and the end dates in your fixed term agreement. Another risk is that certain employers will have a series of fixed term agreements that get renewed many times, and a court will find this type of arrangement to actually be indefinite employment that is merely cloaked in a series of fixed term agreements. In most cases, an indefinite term agreement with an enforceable termination clause will better protect the employer rather than a series of fixed term agreements. Even if it's for a short-term employee, a properly drafted contract that limits entitlements on termination can provide the same level of flexibility and cost certainty at the end of the relationship. That said, if a fixed term contract is appropriate in your circumstances, make sure you work with someone to draft an enforceable contract that minimizes the risks to the extent possible. Okay, and now I'm going to hand it over to Jackson to talk about constructive dismissals.
Thank you, Connie. Good morning, everyone. My name is Jackson Lund. I'm a lawyer and colleague of Connie and Brian's here at Sherrard Coos. So as Connie mentioned, today I'll be talking about the topic of constructive dismissal. temporary layoffs, and remote work considerations. And I'll also be discussing how temporary layoffs and remote work considerations significantly overlap with the concept of constructive dismissal. So constructive dismissal, is a term that is widely used, but many do not have a clear understanding of what the concept is. So first and foremost, let's break that down. So constructive dismissal has been described by the courts as a unilateral change to an essential term of the employment relationship and to the employee's detriment. So an essential term can be either express or implied. A couple of examples include changes to compensation. Typically, that would be an express term, an express change. Changes to an employee's duties, including changes to their reporting structure, and changes to who and which employees report to them. This can also include changes to work location and changes to a remote work arrangement, which I'll get into a bit later. Secondly, and kind of in the second prong, this can also include examples of a poisoned work environment. So constructive dismissal can occur where there is evidence of a poisoned work environment, including harassment under the Human Rights Code, sexual harassment, bullying and discrimination under OSHA and or the Human Rights Code. So again, to determine if constructive dismissal has occurred, the court will consider the perspective of a reasonable employee in the shoes of that specific employee alleging constructive dismissal. So in other words, this is an objective standard, but is based on that individual employee's specific circumstances. So the seminal decision with respect to constructive dismissal is from a case called Potter v. New Brunswick Legal Aid. This is a seminal decision because it lays out the legal test for constructive dismissal. It is also important factually, as the court confirmed that placing an employee on a pay with a suspension with or without pay can be grounds for constructive dismissal. So the facts in Potter are as follows. So David Potter was an executive director of the New Brunswick Legal Aid Commission. Fortunately, the relationship deteriorated between the parties, and they began to discuss what a quote-unquote buyout would look like. Before the parties were able to come to terms of a buyout, Potter took a medical leave. He eventually was able to return from that medical leave, provided medical that he could return. However, before he was actually able to return to the workplace, the New Brunswick Legal Aid Commission placed Potter on an indefinite administrative suspension with full pay. Again, and the background of this was that the employer in this case was still trying to negotiate and get instructions for negotiating a buyout. After Potter was placed on his administrative leave, he sued for wrongful dismissal, where he alleged he was constructively dismissed, primarily as a result of the suspension, the administrative leave. The court held that the employee was constructively dismissed for the following reasons. The suspension was an indefinite term. It had no start date and had no end date. There was no express or implied term in Potter's employment agreement that provided that the employer could suspend him with or without pay. The suspension itself did not accompany and was not accompanied by any reasons to justify the suspension. Ultimately, the court determined that placing Potter on the administrative leave, even though it was with pay, was a substantial change to the term of his employment. So again, this is a very important case because it also outlines the test, but also the chain of analysis for what the court will consider as constructive dismissal. So the court confirmed that constructive dismissal can take two forms. One, it can be a single act or a very egregious act, or it can be a series of smaller acts over a period of time that amount to a unilateral change. So again, moving on to the chain of analysis to determine if constructive dismissal has occurred. This is from Potter as well. The question is, has there been a unilateral change to a term of employment? If yes, second test, does that substantially alter an essential term? And would a reasonable person think so? So again, I'm assuming you're reading the test as well, but I'm sure there's lots of questions, but constructive dismissal is a highly contextual analysis. It can involve a multitude of factors, and there are very few bright lines, if any, or triggers that equate automatically to a constructive dismissal. Again, it is a very nuanced analysis. Now, building on that point, unless expressly restricted, an employer is entitled to manage its employees and manage its workplace, including where and how those employees work. But be alert. There are a number of factors and unilateral changes that often present risks for constructive dismissal that we see in our practice. The first one and the most obvious one is compensation. So the most common type of constructive dismissal can be where there is a change to compensation structure, including both non-variable and variable compensation. Despite some of the narratives and lore out there, there is no hard and fast rule on what the percentage of reduction of compensation is to trigger constructive dismissal. Again, in the new age of commission structures, non-variable compensation, this is a very, very contextual analysis. Secondly, and I'm going to get into this later on, is relocation. Relocating an employee to another jurisdiction or requiring them to return to work can also cause a severe impact on an employee. And where that is not an express or an implied term of their employment, it is a risk that that relocation and mandating that relocation can result in constructive dismissal. Suspension, obviously, is the next one, as we saw with the Potter case. Again, there's no implied right at common law to suspend an employee. Potter confirms that even a suspension with pay can be grounds for constructive dismissal. However, as Connie mentioned in her presentation, where an employment contract allows for a suspension, that will not necessarily equate to a constructive dismissal because it is a term of their employment. And lastly, as I'm going to get into later, layoff. Placing an employee in a temporary layoff can also present a risk for constructive dismissal. Again, this is in the cases where there is no express or implied term of employment that allows for a layoff. So this segues nicely into the next topics, layoffs. So under employment standards legislation, an employer can and has the ability to lay an employee off temporarily. However, there needs to be a layoff provision in an employee's employment agreement. So, as I mentioned before, employment standards in multiple provinces across Canada allow for a temporary layoff that will not necessarily trigger a termination of employment. From a business perspective and strategically, temporary layoffs allow and provide a mechanism for employers to address shortages of work, a slow in operations, seasonal operations, without triggering those statutory termination entitlements that Connie spoke about. However, as I mentioned before, the ability to lay off under employment standards legislation does not protect an employer against a common law claim for a wrongful or constructive dismissal. Again, for an employer to have to legally lay somebody off or lay an employee off, there needs to be a layoff provision in an employment agreement. So moving on slightly, just going to discuss what a temporary layoff is and when a temporary layoff can become a termination. Yet this is provided by employment standards legislation. So for example, in Ontario, where we are today, temporary layoff becomes termination when the layoff exceeds 13 weeks consecutively in any 20-week period. The temporary layoff can be less than 35 weeks in a 52-week period if certain conditions are met. For example, if an employee has their benefits continued under the employer's benefit plan and where the employer pays for those benefits, this can extend that layoff to a period of 35 weeks. In British Columbia, similar to Ontario, where a layoff will become permanent, will become a termination where it exceeds 13 weeks in any 20-week period. In Alberta, we see a slightly longer period. Sorry, a slightly shorter period where if a layoff exceeds 90 days in a 120-day period. So to tie this all back, temporary layoff is a creature of statute and employment standards legislation and is permitted through this legislation. However, for an employer to take advantage of these temporary layoff provisions, they need to still be included in an employee's employment contract. So moving on to remote work considerations, as we see here, again, this is a hot topic, obviously, we come out of COVID or are coming out of COVID, and remote work considerations are, and have become a somewhat norm. So just some stats throughout here. Stats Canada has found that 20% of Canadians reported working from home in 2023 versus only 7% in 2016. So an employee may ask for a flexible work arrangement or have been provided one, which can look and take a multiple looks, including an entirely remote work situation, a hybrid situation where they're working 2 days in office, 2 days from home, or just an in-office work arrangement where the employee can work 1 to 2 days at home at their choice. Again, ties back to constructive dismissal. Remote work and any changes to a remote work situation can cause additional risk for an employer and risk of constructive dismissal. And this is where I'd stress the importance, and we'd all stress the importance of a remote work clause in an employment agreement. And a pure remote work clause can make it difficult to mandate a pure return to work. So for example, we obviously would recommend that you consult an employment lawyer when drafting an employment agreement and including any sort of remote work or hybrid work provision. For an example, the following is potential language that can be included, which the employer would retain their right to have an employee return to the office. So for example, the clause reads as follows: any remote working arrangement can be ended at any time at the employer's discretion, temporarily or indefinitely, and no period of remote working creates any right or entitlement to be a continued remote working arrangement as a term of employment. And this clause was drafted by Sherrard Ku's lawyer as well, and we believe it allows an employer to maintain that flexibility of having to mandate a return to work. So when drafting an employment agreement and including these type of clauses, there are many considerations that an employer needs to consider. Is this an indefinite working arrangement? Is it a hybrid model? And again, this is not an easy task. And again, like I said before, we recommend that you consult with an experienced employment lawyer like Connie, Brian, and I to draft these type of clauses. So practically speaking, there are also many considerations that arise in remote work scenarios. For example, if a remote work employee lives in another jurisdiction, in another province, the employer may become bound to that jurisdiction's laws, including that jurisdiction's employment standards legislation, their human rights legislation, health and safety, as well as tax legislation. This can pose some significant risk as well as some nuances in how to address and manage the employee. So to reduce that risk, we often consider, and employers should consider, provisions to address, permitted work jurisdictions, i.e. where the employee is permitted to work. And again, consider this on the front end when putting together the employment agreement. Employer should also consider the right of the employer to unilaterally change that employee's work jurisdiction, similar to the clause that we discussed in the previous slide. And we'd also want to consider the type of work and the frequency of work that should be done off-site and or in that other jurisdiction. I know I'm beating a dead horse here, but these are all things that pose and present various nuances and can be very, very specific to an employer's business. Again, for that reason, we always recommend to consult with one of us when drafting one of these clauses. So now that we've examined some of the factors that can give rise to constructive dismissal, including how layoff and suspension and or a change to their work location can create risks of constructive dismissal, we're going to look at a possible defense when an employer is faced with an allegation or claim of constructive dismissal. The main defense here is condemnation. So no constructive dismissal can be found if an employee has condoned a change to a term of employment by continuing to work under those new terms, again, for a period of time. Can be very nuanced as well, though. So I would also flag an employer has the burden of proof to establish that an employee has condoned a change. When arguing that an employee has condoned a change, and when arguing this in court, the courts will consider a couple factors. First being the period of time that an employee has remained in that altered position or has remained in that position where their duties have slightly been changed and they've not raised an issue with it. The court will examine evidence of when and how the employee objected to the unilateral change and or if the employee continued to work after that objection and for how long. Again, conversely, the court will also consider any evidence of a written or verbal agreement to a change of employment or to, again, even changes in compensation as well when considering if the employee condoned, i.e., or agreed to that change. So when faced with a claim of constructive dismissal, it can be important, or when trying to navigate these issues, it can be important to try and obtain written or a verbal agreement from the employee before a change is implemented, i.e., or shortly thereafter. The next issue I'll talk about is not necessarily a defense, but it's a factor that can limit an employer's liability when they're facing allegations of constructive dismissal. So under common law, an employee has a duty to mitigate their damages by looking for alternative employment. This is when either they're terminated expressly or whether they've alleged constructive dismissal. The employee still has a duty to mitigate by accepting comparable employment. This includes even with their existing employer after alleging constructive dismissal or filing a wrongful dismissal claim. So again, when viewed objectively, the test for determining whether an employee has a duty to mitigate by remaining in their current position is there any acrimonious or substantially different conditions that have created an atmosphere of hostility? So in other words, going back to the previous slide, for example, if an employee has been subject to harassment, bullying, sexual harassment, it's not a situation where the employee typically would be required to stay in their current role and be subject or remain subject to that treatment. They will not have a duty to mitigate to remain the same employer. The test is, would a reasonable person in the employee's position have accepted the offer of reemployment? Again, this also mirrors the same test for constructive dismissal. So in certain circumstances, it can be strategic for employers to present the employee with a clear opportunity to return to work or remain in their position after the employee alleges constructive dismissal. Again, staying with the theme of constructive dismissal, we'd encourage you to consult with an employment lawyer when considering an offer and in situations where there's been allegations of constructive dismissal, and whether it would be appropriate to make that offer and have the employee continue in that position. There are certain circumstances, as I've said before, where it would not be appropriate. So again, it'd be important to to get ahead of these allegations, it's always important to consult with an employment lawyer in trying to navigate these issues, which are so nuanced. So keeping with the theme of mitigation, the premise behind it is constructive dismissal damages are meant to compensate the employee for a lack of notice to their change, not to penalize the employer for making that change. So a reasonable person should always be expected to accept continued employment as a form of mitigation when the following factors are present. Again, if the salary offered is the same, the working conditions are not substantially different, again, very, very subjective, where the work is not demeaning or where they have not been stripped of their duties, and whether there are any personal relationships that have not become hostile or acrimonious. And these are the kind of four prongs that employers should consider, and we'd often provide advice on is in situations where it would be appropriate to continue and offer reemployment. So at this point, I'm going to hand it off to my colleague, Brian, who will be discussing best practices when terminating the employment relationship the right way, and some of the practices to avoid. Thank you.
Thank you, Jackson. Thank you, Connie. And thank you, everybody. We have a lot of people here today with us, and we appreciate it. I am going to speak about terminating employment, specifically how to do it the right way and not to let you down. I am a lawyer, so I'll talk about how to do it, not to do it the wrong way, some things to avoid. So when you've made the decision that you're going to terminate someone's employment, the frequent starting point is to draft the written communication to the employee. So often we'll take the form of a termination letter. That letter has some items it has to include and some items it should include, and that's what I'll talk about. One of the items that it has to include is the termination date, okay? What will be their last date of work? And that could be that very day because you're planning on handing them this letter in a termination meeting. So that is a must. It has to be in there, and this notice of termination, which this effectively is, has to be in writing, okay? So that's why we're talking about a letter, and we're talking about a termination date specifically. Then your communication, your letter, should set out a few things that explain the situation to the employee, and that starts with what their entitlements are, okay? So they've now been terminated from their employment, let's assume without cause, without allegations of any misconduct. They would be entitled to certain amounts under the Employment Standards Act. Okay? Those would be termination pay, like notice of termination pay, severance pay potentially, continuation of benefits, those sorts of things. Or there could be entitlements in their contract. And you're saying your contract entitles you to this. So you will set out that sort of base starting point. From this termination, here's what you were entitled to. This is what you get, no matter what. Okay? And there might be a what, which I'll come to in a second, which could be an offer from you to say, we'll give you something more, and you're going to give us some items in return. And I'll get to that in a brief moment. Before I get to that step, when we're talking about ins and outs and decisions about the content of the termination letter, you're not required to put the reason for termination in a without cause or no misconduct termination of employment. Okay? If you are alleging misconduct, just cause, the consequence of which is they do not get a notice compensation, you are required to put the basis upon which you are terminating their employment for just cause in the letter. Okay? So that doesn't have to be a whole treatise. You don't have to attach or append documents proving it, but you have to set out the basis upon which you've made that decision. Okay? So that should be reasoning that you can support and stand behind. Because as it goes forward, and if it gets litigious, you will have to. And you will have to establish that those are the facts, or at the very least, that you had a real substantive reason to believe in those facts and that that's the way you proceeded. Okay? You also should be pretty comprehensive in that list. It would be very difficult to add things later on and say, oh, this was also very important, but we forgot about it when we made the termination letter. Okay, so you want to be very accurate. You're going to have to defend this, and you should be comprehensive. okay, in the list of reasons why they're being terminated for cause. Okay. So absent that, these are more of the optional pieces, but frequent. So frequent but optional might be an offer. So you're going to say, and you're going to be very clear in your letter, and this is important. Here's what you're entitled to. ESA gives you this, contract gives you this. Separately, you're going to get that. Separately, we will give you this extra, this offer, in exchange for some items back from you to us. So that's where you might offer a little bit more pay in lieu of notice, for example, in exchange for a release, which is a document coming back saying that they will not sue you to try to get more. It's basically putting everything to bed, saying, okay, here's the terms on which we're parting ways. Okay. That release comes into play only where you're making that additional offer over and above what they're already entitled to. Okay. So that's that concept of a trade. And I'll talk about some other things that you can add in a minute, but you need to make sure when you set out this letter that they're at least getting their statutory minimums under the ESA, and that it's clear that they will get those whether they agree to your extra amount and your extra conditions or not. And I will talk about specifically a case where that didn't happen and it turned out very poorly for the employer. So if we can get the next slide, I wanted to talk about a couple of other additional items that you might see in a termination letter. You might decide to put them in. And so these wouldn't be in every termination letter, but they may be appropriate. And that might be, for example, a non-disparagement agreement. Okay, so that basically means we're going to part ways. This type of a clause or provision is not an obligation the employee owes you. Okay? So again, not something you can hold them to in exchange for just giving them what they're already entitled to under the ESA or their contract. Okay? The concept is you can't say bad stuff about the company or its employees. Okay? So if you're offering them more and this is the new bargain, then you can come back and try to enforce that non-disparagement against the value of your offer or settlement that they accepted. Okay, so appropriate and useful most often if you have something about a particular employee that you know is going to be concerned. Not a lot of harm to include the provision where you're giving them extra. It's something that you can ask back. Very common, I would say, to find a reminder regarding confidential information. So employees actually are bound to honor the confidentiality of confidential information, regardless of any extra offer that you make to them or not. It's a duty that they do owe. So you might decide to remind them about it. Sometimes it can look strange in a termination letter for a position that would obviously not have any access to confidential information. So be thoughtful in terms of the content of your termination letter is, I guess, the highest level takeaway of this, but that's another thing you'd want to consider. And it might even get into more specific restrictions like non-solicitation, less so now, but on competition. Is it helpful or necessary to give the employee a reminder about those restrictions that exist? Theoretically, if you don't have any of those restrictions, offering them more at the point of termination would be an opportunity to bind them to those kind of restrictions. Okay, that might be costly to do that, but strictly speaking, you're making a bit of a new bargain, so you could add it now, or at the least remind them of what exists. Now, what not to include in a termination letter, if we can grab the next slide, please. The termination letter should not include a requirement to provide a release in order to receive the things that they're already entitled to. Repeating that point, that's important. You shouldn't put anything in there that could be construed as retaliatory or discriminatory. What I'm really saying is, again, be mindful of the content, be careful of the content, and appreciate that the employee at this time is nobody likes to have their employment terminated. And if it ends up in the hands of a judge down the road, he or she will also view it from the lens of the employee who was terminated. And they might not read the letter the way that you intended. So just limit the language, be accurate and precise about it, and not so flowery. You shouldn't be referring at all to a return from a parental leave or anything like that. Just don't add anything that doesn't need to be in there in your termination letter, frankly. Also be sure that your termination letter is accurate. Okay? So if you're setting out the entitlements on termination that they have, you need to be accurate about it. You don't want to put anything in there that misleads the employee. Okay, there are cases that demonstrate that an employer will be held responsible for doing that, whether it was intentional or it was a mistake or a slip. What I'm saying is be very careful, because a mistake or a slip could still bite you. Again, context, very sensitive time for the employee, and they're considered by the judges to be very vulnerable in this situation. Likewise, just again, stay away from emotional or subjective statements about their conduct. If this is particularly the case, if we're talking about a dismissal for cause or for misconduct, and you have to explain your reasons, back to my point, be accurate about it, be objective about it. You don't need to insert flowery language that sort of goes over the top about your dim view of their conduct. Okay? It should be very clear and forceful, but just be very careful and deliberate in the words that you use. And I'll give you some examples as to why later. Now, you've got your letter. You're ready to have the meeting. Nobody's looking forward to it, typically. What do you do? Okay, so you're going to bring your letter, and if there's a release, you bring that with you to your meeting. You set up the meeting in a private place, okay, to respect the employee's privacy as much as possible. Okay, and you should have 2 company people in that meeting. Typically, human resources is one person, and their direct manager of the employee might be another. That's sort of just a typical thing. It's not a rule. It doesn't have to be a certain person on behalf of the company, but you want one person to lead the meeting, and you want the other person to be there really as a witness and to take notes. There could be circumstances where you want to do something a little bit different, or the manager is there for a specific reason, but as a general approach, you want to have those 2 people wherever possible for those reasons. Okay, and you want to keep the meeting brief. I think that goes without saying. The meetings are typically not comfortable. The employee could be shocked or not, or whether they should be shocked or not, they might still be shocked or profess shock, and they might argue with you. Okay, it's another reason to stay away from getting into the rationale of the reason for termination, if it's a without cause, or not talking about misconduct, the reasons for the termination. Okay, it's a bit of there's different schools of thought here, and I think it's fair to admit that in those circumstances, emotions are high, and there can be a temptation to give some explanation. You can tell them it was poor performance if you're prepared to stand by it and defend it, and it's true. Don't say things that aren't true. Don't say things that are not accurate and that you can't defend. The most interesting word in this regard that I see very frequently is restructuring. And that can mean a couple of things. That could be an actual restructuring where you're eliminating a position, you're not backfilling it, or you're changing things. A lot of times I think people use that word as a bit of a platitude, just a sort of transition word, or just something they think they can say to make the person feel less bad, the employee who's being terminated. It doesn't. They go and they look to see if the job's been posted, and it always ends up in a demand letter if they get a lawyer. Okay, so just be honest and accurate in your communication. Okay? You want to review the key parts of the termination letter, explain it in terms of that option. You're going to get this no matter what. Here's the additional that we're offering if you agree to the non-disparagement, sign a release back. Okay, and you should allow them time to consider this offer, which is what it is, and that's like at least 3 business days is our typical recommendation. In fact, if the employee is keen to sign it on the spot, I've had some clients who said, no, please don't, take it away and sign it. I don't know that that's a hard rule. You have to just decide how you feel about it. It's nice to have the paper signed, but at the very least, do not push them to agree on the spot. Okay, even if you say in your letter you're giving them 3 days. Okay, make sure they have time. We can look at the next slide, please. So just quickly, a little point as to what might come next out after that termination meeting. Service Canada might come back to you. Employees wouldn't necessarily be entitled to employment insurance if they've committed significant misconduct. Service Canada tends to give it to them anyways as a general just non-analytically supported observation of mine. They might reach back to you looking for some documents. They'll usually do this in a phone call. You're required to cooperate. Okay, you have to give them an explanation of what happened. You should have provided the record of employment. If you haven't, do that and provide that. There are limitations. You're not required to just do anything they ask. So if they're asking you to do something, you can ask for that request in writing, and you may or may not want to seek some advice of a professional regarding what you have to do and what you don't have to do. If you go far enough down that road and participate, it could have some consequences in a civil case that follows. So if we can grab the next slide, please. What are some of the items that would say you might be terminating the wrong way? And what are the potential consequences of that? The potential consequences, and this is like the good lawyer stuff you always get, but it's true, and you need to be aware of it. It's money. Any of these items that I've talked about here in terms of the right way and the wrong way to do it, if you mess it up intentionally or accidentally, there could be money on the line. And I'm specifically talking about bad faith damages, because employers have an obligation of good faith towards their employees. I've used the analogy many times that as the employer, I understand you're all just people yourselves and you're human. Nevertheless, you're a representative of the corporate entity, the employer, and they're the parent. The employer is the parent. You have to get things right, and the employee doesn't have that same obligation and responsibility as you do. That's your good faith obligation. Be respectful, be clear, be right. Okay? You're obviously not going to do anything that's going to embarrass the employee. You should actually take steps to try to avoid that. How public is this dismissal? What's the messaging that comes out afterwards? Just think of these things very carefully and understand that if you do things particularly poorly, I'll give you some examples so you can try to latch onto things. It could have monetary consequences. And specifically, if you don't comply with some of those ESA points, you have to, i.e. provide them their record of employment, pay them their notice and severance pay within either 7 days or your next payroll, whichever's later. There are details, there are rules. And then I would only say there is a bit of a caveat if you're negotiating a resolution or something. Hopefully you have some legal assistance, and hopefully, frankly, at that point, the employee might as well, because you can maybe still handle things, but just be very mindful. What I mean by that is you might have some comfort level of going outside of paying out their severance pay after 7 days because you're still working on a bigger settlement. But the minute you don't do that, you're offside the ESA, and that's, generally speaking, not somewhere the employer wants to be. Okay? So the employees, when these bad things happen, employees can seek aggravated damages or punitive damages. Aggravated damages compensate the employee for the mental difficulty, the damage of going through this, of the employer conducting things the way they conducted things. That's compensation to the employee for the bad feelings. Separately from that, punitive damage are another monetary award specifically designed, not, Joe deserves $20,000 because of the way he was treated and he felt bad. This is, Joe might have already got that $20,000, and we're going to add $30,000 punitive because what the employer's done is so bad that we need to send a message to this employer and other employers not to do that. So we'll give you some examples. The next slide, please. Aggravated damages. So again, these are the compensatory ones. So in this particular case, you had a long service employee in the construction industry. He was on a medical leave. It was recovery from a back surgery. And it was really the how the employer went about it that was the problem here. Thank you. He was terminated within a couple hours of returning from his leave. There wasn't a robust examination of his accommodation or anything like that. And here's, I guess, one of the, as I said, things to take away. In that termination process, the employer said you were being terminated for financial reasons. And then when it actually got down to trial and employee's lawyer pushed, the company wasn't willing to disclose financial documents to support the fact that financial reasons were the true issue. It was important here because the employee had disability issues, and the trial judge did decide that the employee was dismissed at least in part because of those physical limitations. Okay, so giving a different reason, whether it was to try to avoid liability or is try to make the employee feel better. It was very harmful to the employer. Okay? They said something during that termination process they weren't prepared to stand behind, and they couldn't prove. Okay? So this employee was awarded $50,000 aggravated damages for the mental health and suffering. A quick takeaway here also, that type of damage award doesn't require a doctor giving evidence. It's the Court of Appeal reviewed it. The trial judge didn't award it initially because there was no doctor. The Court of Appeal said, no, it's a spectrum, and they heard from the family, they heard from the employee, and they were awarded $50,000 on top of the notice amount that they were entitled to, which in this particular case, if I recall, was about 2 years of notice, given the length of service. So it's a significant additional amount on top of all the other stuff we're talking about for notice, compensation of notice. Next slide, it deals with a punitive damage case. So again, this one is more focused on punishing the employer and deterring the actions of the employer amongst other employers. So in this particular case, it was about a 3.5-year employee dismissed without cause. They were offered the statutory minimums. Okay, so here we'll pay you your ESA. They have to pay the ESA. The problem is that the employer said, this will be a settlement. You'll be releasing us from claims. We're going to pay you this. You can't sue us. And the employee here actually said, I don't know if that's right. Employer sent them a check. And after a period of time, so the employee didn't actually end up signing the release, but after a period of time, the employee actually cashed the check because they really needed the money. And so in the lawyer world, which is, I guess, where we are, you could still say the bargain was struck, right? The employer said, pay this and you can't sue us. And then the employee did cash the check. When that got around to court, the court, again, was very unhappy with the conduct of the employer. You cannot hold the employee hostage, essentially holding their ESA amounts hostage on conditions you're not entitled to impose. And they knew the employee was in a financially precarious position, and they were using it as leverage in the termination process. And so there were $25,000 awarded in punitive damages. I think, that was influenced as well by the size of the company. Like, frankly, for conduct like this, I'm not surprised to see a number like that at all. I wouldn't have been surprised if the number was a bit higher even, because this is pretty egregious. I would say very egregious. Separately, as just a quick point, the employer had written a letter as well saying, here's a reminder about your confidential information. We think you're using it. Cease and desist. The letter was very heavy-handed in tone, but it was completely factually accurate. There was a reason for sending the letter. So the court decided, okay, we're not considering that in the bad faith conduct. So lastly, in terms of summarizing the bad faith issue and things that you can take away, next slide, please. Don't assert just cause unless you have substance behind it. Okay, you're going to lay it out, you're going to stand by it, and you're going to prove it. There's a very quickly, like a smoke and fire thing. You might not ultimately win that case. A judge might not agree that the reasons you have for terminating for just cause actually justify termination for just cause or willful misconduct. But if you've advanced a case and made a position that you at least could defend, win or lose, then you're still likely to be okay, because you haven't just made something up, or you haven't proceeded on the thinnest of evidence. Okay? So I'm not saying you can never do that, and if you don't win for just cause, you're necessarily going to pay these extra damages. That's not the case. Okay? It may be the case. It's going to depend. Treat the employee with respect. It's a bit, should go without saying, but I will say it. It's very important. As best you can, remember the employee will be considered to be very vulnerable and at your mercy. So be respectful, regardless of the history. Comply with the statutory termination requirements, no exceptions. Be very careful about that and make sure that happens. All of this will be and could be complicated litigation strategy, right? So that was what I hinted at before. Okay, we're negotiating with an opposing counsel, so we're not going to pay all that severance lump sum right now because maybe the employee actually wants salary continuance, or there could be any number of reasons, but your lawyer, or you should have gotten clarity that that's okay with the employee and their lawyer in writing, as an example. So there's a lot of moving parts. If you're talking about salary continuance or lump sum, there's a lot of moving parts there as well, as there were some questions about that. But all of it to say, there's always going to be details and nuances. What I've laid out here are the basic points that you should always remember and consider. So with that, I am going to pass it over to Connie to start off in responding to some questions. And we'll do our best. There were a lot of questions, so we won't be able to get to them all, but we'll get some key ones.
Thanks, Brian. So there were a lot of really good questions, and we're going to try to do our best to address a number of them. One of the questions talked about providing statutory notice for just cause. So like I mentioned earlier on in the presentation, there are effectively really two standards of cause. There's that common law standard and the ESA standard of willful misconduct, willful neglect of duty, or disobedience. And it ultimately, it's going to sound like a very legal answer, but it really depends on the type of misconduct that you're contemplating a for-cause termination for, and whether or not looking at the facts of the case and the misconduct itself, that would meet that higher threshold stipulated in the ESA that would disentitle an employee to their statutory notice. And it often can be challenging to decide and make that determination, which is why we would recommend that you speak to your legal counsel about that. There were also a couple questions as it related to fixed term agreements. And specifically, what would be considered an enforceable termination clause in a fixed term agreement? So the default assumption is if somebody is terminated midway through their fixed term contract, they would be entitled to the remainder of the contract. And depending on the length of that contract, if it's a 3-year contract and someone is terminated 2 months in, that could be a significant liability for the employer, which is why we recommend having an enforceable early termination clause, which effectively contracts out of the default. And an early termination clause would stipulate that if the contract is terminated before the end date, then the employee would receive their employment standards minimum entitlements, which in effect then becomes based on their length of service rather than the entire length of the entire contract. Another question as it related to fixed term agreements is if the agreement has expired already, does that convert the agreement to an indefinite term? And yes, it would. If the employee has continued to work beyond the end date of their fixed term agreement, even if it's just 1 day, it's effectively converted the terms of their employment to an indefinite term. And now, you may be in a situation like that, and there is a way to try to mitigate risk in that circumstance where you can provide the employee with a new employment agreement that contains an enforceable termination clause, and also offering them what we know contractually to be sufficient consideration in exchange for them executing that employment agreement. So there are ways to try to mitigate that risk, even if you do find yourself in that challenging spot where you have someone who's in a fixed term agreement and has unfortunately worked past the end date. Another question on, whether or not a fixed term agreement would be appropriate for a seasonal worker. And really, yes, it could be, when you're dealing with sort of seasonal workers or workers that are being brought in for specific projects where there's really a end date specified for the project, a fixed term agreement might be appropriate. That being said, there is no really additional risk or liability if you decide to offer them an indefinite contract that has a valid termination clause. And one of the issues that I talked about with fixed term contracts that becomes tricky is you're taking on a lot of administrative burden because you want to make sure that you're going by the exact fixed term end date and making sure that you're not going beyond that. The last question I'm going to talk about is whether or not it's possible to put new employment agreements in front of an existing employee who either may not even have an employment to begin with, or may simply have just an offer letter that doesn't have a termination provision. And the answer is yes. You definitely can offer updated or new employment agreements to your existing employees, so long as you're making sure that you're doing it properly and fulfilling certain criteria. So I talked about the concept of consideration earlier, but that is something that is really important to consider when you're thinking about offering an existing employee a new employment agreement and determining whether or not what would be considered reasonable and sufficient consideration in light of the circumstances, particularly in light of the fact that they may be a really long service employee and their common law notice entitlement may be significantly greater than what the ESA minimum entitlements are. I'm going to move it over to Jackson to take a few questions as well before we get to Brian. So
Thanks, Connie. So one question that keeps popping up in the chat is, this one is, should an employment contract discuss the employer's ability to suspend an employee, or does an employer's policy, which allows for a layoff or suspension, is that enough to defend a claim of constructive dismissal? So the best practice we obviously recommend is that a suspension provision or a provision allowing for a layoff should always be in the employee's employment agreement, included as an express clause. That said, an employer can append a policy, including a corrective action policy or a layoff policy, to the employment agreement and have the employee sign that appended policy, which arguably would mean that this policy is a term and condition of employment. Where a policy is freestanding, quote unquote, and what I mean by freestanding is where it's not included or appended within an employment agreement, it is unlikely that a court would consider this as a defense for constructive dismissal, because the court would not consider the policy or the freestanding policy as an express or implied term of employment. In other words, it will be hard for an employer to rely on a blanket policy not included in an employment agreement to defend a claim of constructive dismissal where an employee is laid off temporarily or suspended. Another couple questions have come in regarding suspension. So when suspending an employee with or without pay, is this automatically considered a constructive dismissal? The short answer to this would be yes, where the employee's contract does not reference the employer's ability to impose a suspension, or where there is no written employment contract. However, again, with that said, going back to that Potter case that I briefed you and summarized, a suspension will not automatically trigger a constructive dismissal, where, for example, let's say the suspension is very brief, 1 to 2 days, it is with pay, and where the employer provides clear reasons for the suspension. Again, those were the factors that were absent in Potter. Even if those factors are included in the suspension, there still is a risk of constructive dismissal, but again, it could reduce the liability for the court, or for the court to find that there has been a constructive dismissal. Moving on. One of the questions around decreasing salary is, if an employer agrees to decrease their salary and signs off on it, could this still be considered a constructive dismissal? And the classic lawyer answer to this is, it depends. So where an employee's change to compensation, where there's evidence that that change was clearly understood, was not a significant amount, and where the employee agreed to that change and signed off on it, that could be evidence of condemnation. However, there's always risk in these situations where an employee can later claim, oh, I didn't understand the change, even though I signed off on it. And again, as Connie talked about, there's an imbalance of bargaining power between employees and employers. So there is still a risk that even with a written signature, that this could be a constructive dismissal. Again, these are the type of nuances I was talking about, and it's very important to contact an employment lawyer in these situations.
Thank you, Jackson. So I have several questions I want to get through in terms of termination, and just sort of quickly on those 2 points. I would say fairly strong evidence. If the employee agrees to something in writing in the new terms, it's very strong evidence, and your risk is rather low, absent evidence of, again, undue influence or misunderstanding. Also, with respect to putting employees off work, so the most common situation, what we're talking about when we hear the word suspension, then employers use that word. We're getting people away from using that word because a suspension is a discipline issue. If someone has done something in the workplace that you suspect has happened and it's a bad thing, harassment, something like that, you're going to investigate because you have to. And pending the outcome of that investigation, you will usually put that person out of the workplace, particularly because of the nature of the accusations. And what we call that is an administrative leave pending the outcome of the investigation. It is with pay. It's not incorrect to say that there's always some risk around that because you don't, strictly speaking, have an entitlement at common law to do that. The risk is exceedingly low. Like, that's the way to do it. Bottom line, if you have to investigate someone and there's good reasons to have them not in the workplace because we're talking about harassment or bullying, administrative leave with pay. Talking about termination, there were several questions and several questions regarding benefits, which I'll sort of cobble together and give an answer. So the Employment Standards Act in Ontario requires that you keep benefits in place during the Employment Standards Act notice period. So that's that 1 week per year of service up to 8 weeks. Okay. And it's everything. Okay. So that's disability, that's medical, dental, that's death, that's pension. All of those things stay in place during the ESA notice period, regardless of whether you are paying them instead of actually giving them working notice. Okay. So there was a question about, can you just handle it through pay in lieu? No, you cannot. Not for the ESA. Okay. There was a question, do you have to continue that for the severance period? And by that, I assume we mean ESA severance, that additional 1 week per year of service. If they've been with you for 5 years and certain other conditions, size of payroll have been met. Answer is no. Okay. Severance pay is a lump sum payment of money that they're entitled to, and it does not influence benefit continuation. Benefit continuation is also a concept under the common law, okay? Because the common law is says you have to put the employee in the same position they would have been in had they stayed working with you for the common law notice period, which could, as you know, could have been 2 years. But do employers keep benefits going for that long? They typically do not. They might keep medical, dental, particularly if you're still trying to negotiate an outcome. But strictly speaking, if an employee was to pass away, we're outside the ESA period, so your disability benefits are not in place anymore because your insurer won't cover it past the ESA period, and you haven't purchased more, very expensive. If that employee became disabled during the common law notice period, you could have an issue. Because common law does compensate with money. It's all about compensating with money. So in the common law period, you're not required to keep the stuff in place. If you don't keep it in place or can't keep it in place, you'll have to compensate by money if something happens during that period, unless you've come and struck your bargain and you've got your release. So that's the benefit of getting to an agreement and getting a release. Okay? So those are how some of those moving pieces work together, overlap, run sideways, or sorry, side by side, is what I mean to say. In respect of, so there was some other interesting questions, and I'm really trying to hit some just before we wrap up that I think are widely applicable to everybody. They're general questions that everyone can see value in. If we haven't got to your question, please follow up with someone. Service at 4 years, 11 months. So the person who asked this question, very, very intelligent and picking up on a detail, and probably knows the answer, but an employee who has 4 years, 11 months service, if you terminated them sort of that day, how would that impact their severance pay, right? So we're assuming employer's big enough to be a severance employer. The decision about whether an employee has reached 5 years of service must include the ESA notice period, whether they've actually gotten the notice or you've paid them in lieu. So with this specific example, 4 years, 11 months, if that extra 4 weeks of notice of termination, either pay or actual notice, takes them across the 5-year threshold, they're now across the 5-year threshold, and they would also be entitled to severance. Okay. There was another very good question that I think is helpful to everyone, because particularly if you've got a contract that has language that says you're entitled only to the minimum entitlements of the Employment Standards Act, but at the time of termination, you decide to give them a little bit more. Does that invalidate your termination provision because you're now sort of doing something different than your termination provision says? And the answer to that, so we always have to be a little bit careful. You know, the courts are on a mission. I haven't had that argument put back on me. I would feel quite comfortable defending that to the cows come home with the answer no. Okay. You've got a provision, it's enforceable, it's defensible. You're making an offer to settle any possible litigation and resolution with the employee. It's accepted, you get a release. It's not an admission that you don't believe in your termination provision. And it would not be viewed that way by the courts. So, like I said, thank you for all the questions. There's plenty of them, but this is going to bring us to the end of our program today so that everyone can get off to their regular duties and business. We hope that you found it very informative. The video and the slide deck will be available on our website in the next day or so. Okay. If we didn't get a chance to answer your question, please follow up, drop a line with any of our lawyers that you can find on the website. Our next HR review will take place on September the 17th. The topic's still in the design phase, but it will be announced and we'll send out an invitation when we have that ready. If you're on our mailing list, you're going to get that invitation. If you're not on our mailing list, but you want to receive our briefing notes, our newsletters, our invitations to seminars and workshops, then please subscribe to the through our website. There's a big red bar on the bottom of every page on our website where you can subscribe to our mailing list. And quickly on that note, this is obviously a very topic of great interest. We have over 100 questions and a lot of activity there. So worth mentioning that we have workshops focused specifically on terminating employment and those issues. They're all full, but you know, certainly given the interest, we hear you and we want to help you. So we'll probably arrange for some more. So keep an eye out, get on our mailing list, and you'll always be kept up to speed. So finally, we'd be very grateful if you would fill out the feedback form that's going to pop up on your screen in a moment after we close the webinar, because we always take those away and we read them and we try to adapt, change, and provide the help that we want to give you. So thank you again, everybody, for joining us. We really do appreciate you taking the time and hope that you all have a great day.